There are different cases, of course. I will talk about the one, for example, you are not a sanctioned person, you own Eurobonds or other securities issued by a Russian company, which is itself sanctioned in Switzerland or EU. Either the company itself is sanctioned or a major shareholder or someone in the top management is sanctioned, and the assets of this company are frozen. Under EU regulation 269, no funds, economic resources may become available to such company or to such shareholder of sanctioned shareholder or top manager. However, the company itself is not the owner. It doesn't hold the shares. If the shares are transferred, sold, the only beneficiaries of the transactions will be the buyer and the seller, not the company itself. And that's why such transaction is possible unless other sanctions are involved of a different regulation, 844, which restrict transfer of certain shares issued after a certain date, but that also has to be checked separately. What do you do if your bank does not want to transfer shares? Such shares, you can again get a legal opinion and try to convince your bank to make such a transfer. What if I do not want to sell securities of a Russian issuer at a discount? What else can I do? Actually, Russian companies themselves have various programs under which they either redeem their securities or make coupon payments. So you can, for example, check the conversion of ADRs into shares of a company. If it's a Eurobond, you can also get a confirmation from a Swiss or European bank, and that you are an owner, and then you can get coupon payments or get your securities redeemed. You can also take advantage. Of the forced transfer of securities rights records to National Security Depository. Also, I would like to mention that there may be a risk if you have an S account for your shares in Russia. If you are a non-Russian holder of securities, there may be a risk payments will be frozen on this S accounts.